Welcome to this week's comprehensive update on important developments in tax and corporate laws. Each week, we bring you carefully analyzed judicial pronouncements and regulatory updates that have a direct impact on taxpayers, professionals, corporates, and businesses. Let us begin with the key highlights under the Income Tax Act. The first major update comes from the Gujarat High Court in the case of Parag Rameshbhai Gathani versus Income Tax Officer. In this matter, the court examined whether the initiation of proceedings under Section 153C was valid when the satisfaction note was recorded almost 4 years after the search and nearly 2 years after completion of assessment in the searched person's case. The court observed that such an extraordinary delay demonstrated a clear lack of timely satisfaction by the assessing officer. Consequently, the notice issued under Section 153C was held to be unsustainable in law and was accordingly quashed. This judgment reiterates that jurisdictional prerequisites must be fulfilled promptly and cannot be exercised at leisure. Moving to another significant ruling from the Ahmedabad Tribunal in the case of Bhavnagar Shrimali Kantaband versus Commissioner of Income Tax Exemption. The issue pertained to a trust incorporated after the 1st of April 2021, seeking conversion of its provisional registration to regular registration under the amended Section 12AB. The tribunal clarified that registration cannot be denied outright simply because the trust's objects are directed towards a particular community. It held that as long as the genuineness of the activities and the charitable intent are satisfactorily demonstrated, the trust is entitled to registration. This ruling strengthens the principle that approval should be based on statutory conditions rather than subjective interpretations. Next, we turn to an important decision of the Kolkata Tribunal in the case of Daniele and C. Officine Mechanica S.p.A. versus ACIT. The tribunal examined whether an unsigned assessment order, whether issued electronically or in physical form, could be considered valid. It held that Section 282A mandates the signing of every assessment order, irrespective of the medium through which it is communicated. Therefore, an unsigned order is legally invalid and must be quashed. This ruling upholds the importance of procedural compliance in assessments. Another notable update is from the Delhi Tribunal, which dealt with exemption under Section 54. The assessee had sold a property and invested the sale proceeds in booking a residential plot with YIDA in March 2009. However, the registration and possession of the plot were delayed beyond the statutory period of 2 years. The tribunal observed that the delay occurred solely due to procedural lapses on the part of YIDA and not due to any fault of the assessee. Therefore, the exemption under Section 54 could not be denied. This decision reinforces the view that genuine investment intent should not be defeated by administrative delays. We also have an important ruling from the Bombay High Court in the case of Sir Jan Sechi JG Poi Charity Fund. The issue involved whether Form 10 had been validly filed when the ACC Trust specified the accumulation purposes by referring to a detailed trustees' resolution due to limited space in the form. The court held that such disclosure was sufficient compliance with Section 11(2), read with Rule 17. Therefore, reopening the assessment on the ground of inadequate details amounted to a mere change of opinion and was required to be struck down. This strengthens the principle that reassessment cannot be used as a tool for reviewing previously accepted positions without fresh material. Let us now move to significant developments under the Goods and Services Tax Law. The Delhi High Court delivered an important judgment where an ex parte demand order had been passed against the petitioner due to non-filing of reply and non-attendance at the personal hearing. The petitioner argued that the lapse occurred due to an oversight by the consultant and absence of access to the GST portal. The court observed that the assessee had not been afforded an effective opportunity of hearing, which is a fundamental requirement of natural justice. Accordingly, the order was set aside. In another case from the Karnataka High Court, multiple adjudication orders were passed against the assessee, some of them ex parte, for different assessment periods. Considering the interests of justice, the court set aside these orders and remanded the matters for fresh adjudication, ensuring that the assessee receives a fair opportunity to present its case. The Telangana High Court addressed an issue relating to cancellation of GST registration due to alleged non-existence of business premises and discrepancies in rental documents. After analyzing the evidence, including physical verification reports and inconsistencies in the documents furnished, the court upheld the cancellation of registration. It held that the petitioner failed to establish genuine business operations, and therefore there was no ground to interfere with the cancellation order. These were the key judicial updates for the week in the domain of tax and corporate laws. Each of these rulings carries practical implications for taxpayers, trusts, corporates, and professionals dealing with compliance and litigation. Staying informed is essential for proactive planning and risk management. We will continue to bring you detailed weekly updates to keep you aware of the latest legal landscape.